Thank you, everyone. Just sort of talking through what I think is a fundamental part of new insolvency legislation that's come into force recently. So what we'll be talking about this afternoon is an initial introduction to the Corporate Insolvency and the Corporate Governance and Insolvency Act 2020. If we can move on to the next slide, please. I should apologise, I don't want to sound like Boris Johnson in his daily press briefings, but next slide please might come up a couple of times during this. So initially I'll be giving you an introduction to what I'm going to refer to as CIGA throughout this talk. I'll talk about the impact in particular that CIGA has on supply contracts. Paul will focus on the practical issues that relate to the loss of termination and other rights against insolvent customers, and go through some practical guidance and tips, and then we'll wrap up the session with a Q&A. So by way of introduction to CIGA 2020, so that's the next slide please. The Act came into force on the 26th of June of this year. There are certain elements of it which does have retrospective effect that goes back to, in some cases, to March. In my view, it is the biggest change to insolvency legislation in decades. There have been lots of ancillary bits of insolvency law that's changed over the years, but prior to this, I'd probably say that the introduction of the Enterprise Act in 2002 was the next most recent fundamental change to insolvency legislation in recent years. CIGA has been pushed through quite quickly, and the government have in some ways just rushed it through Parliament as a response to the coronavirus crisis in particular. It's got a combination of temporary provisions which have been brought into place with the coronavirus pandemic in mind, but also introduces a number of permanent provisions which actually have been introduced initially by David Cameron under his government quite a few years ago, but they are now in place. CIGA in itself applies to corporates, and I'll go along the next slides into a little bit more detail about the types of corporates and companies it applies to. As things stand at the moment, CIGA doesn't apply to individuals who are insolvent, but again, I'd say watch this space. There may be similar or secondary legislation which brings about certain elements of CIGA and applies it to individuals as well. The application of CIGA is very much to introduce a debtor-friendly process of insolvency legislation and an insolvency regime into the UK arena. Some people will say that elements of CIGA mirror things like Chapter 11 bankruptcy in the United States, and there's a lot of other European countries as well that are introducing more debtor-friendly insolvency and restructuring regimes at the moment. So certain elements of CIGA very much have that in mind. Bearing in mind that this talk today is geared towards the impact of CIGA on suppliers, I will be talking mostly about the elements which impact on suppliers rather than the insolvent debtor themselves, but that's something to bear in mind, that this is a debtor-friendly piece of legislation. So moving on to the next slide, in terms of who CIGA applies to, as I mentioned, it does predominantly apply to companies, and that's companies that are English-based companies, Scottish-based companies, Welsh-based companies. There are certain elements of CIGA which also applies to Northern Ireland, but some of the provisions are slightly different, so do bear that in mind. It also applies to companies that have a centre of main interest in the UK and use English insolvency processes, so bear that in mind as well. CIGA does apply to LLPs, and it will apply to some but not all charities and some but not all not-for-profit organisations. In respect of charities, whether CIGA applies or not, it will depend on the way in which the charity is incorporated. So charitable companies are covered by CIGA, community interest companies are covered by CIGA, CIOs, charitable incorporated organisations, are covered by certain elements of CIGA, but not all elements. But bear in mind that any charities which are incorporated by Acts of Parliament or Royal Charter, CIGA does not apply to. When I talk about whether it applies or not, I mean as an insolvent or potentially insolvent entity, can these types of organisations benefit from CIGA? So in terms of what I'm saying applies, I'm talking about the insolvent entity there. In terms of the supply contracts element that we'll come on to, there will be ways in which if the debtor or the insolvent entity is a company, an LLP, or an incorporated charity, then anyone dealing with them will be impacted by CIGA. So in terms of the, moving on to the next slide, in terms of the impact on suppliers itself, CIGA in itself has lots and lots of different provisions, but in my view there are 4 particular provisions which have an impact on suppliers to insolvent entities. So the first is the introduction of a statutory moratorium, which is a new moratorium that's been introduced. The second is the introduction of a new restructuring plan. The third is the current restriction on winding up petitions. And the fourth, and that's going to be the main focus of today's talk, is the changes that CIGA introduces to termination and other clauses within supply contracts. So moving on to the things in particular to know about this new statutory moratorium that CIGA introduces. CIGA introduces a new standalone short-term moratorium that insolvent debtors can benefit from. The premise of the moratorium is that directors will stay in control, but an insolvency practitioner will be appointed as monitor. The moratorium in the first instance will be for an initial 20-day period. It can be extended for a further 20 days without creditor consent, and thereafter any extension has to be gained through applications to court. The impact on the moratorium is that it prevents suppliers from commencing or continuing any sort of legal process against the insolvent entity. It prevents landlords from forfeiting, it prevents goods and assets from being repossessed. So it's very similar to the moratorium that's currently in place in respect of administrations and the notice of intention period, or the CVA small companies moratorium that's been around for a few years now. As a supplier, and we'll come on to how the moratorium also impacts on supply contracts. As a supplier, one of the things to bear in mind is that with a moratorium, there will be certain ways in which payments of continuing debts and prior debts are dealt with. So in effect, for any pre-moratorium debt, there is a payment holiday. So as a supplier, you won't be able to take any action in respect of any debt which has been incurred in respect of an obligation which arose prior to the moratorium coming into effect. Having said that, if there is a subsequent formal insolvency, then any pre-moratorium debt will gain super priority in the subsequent insolvency. So there are protections in some ways for suppliers and suppliers to insolvent businesses, but generally the moratorium will impose a payment holiday. There are certain moratorium debts which do continue to be paid, and unsurprisingly to a lot of people listening here, the insolvency practitioner who's acting as a monitor will have their fees and expenses paid. In terms of other debts which have to be paid during the moratorium period, any ongoing supplies during the period of the moratorium do have to be paid. And if there's any extension of the moratorium applied for, then statements have to be made by the directors and the insolvency practitioner confirming that moratorium debts have been paid. So that's in a nutshell the things that as a supplier you might want to know about the the new statutory moratorium. Moving on to the new restructuring plan. The new restructuring plan has been introduced by a new Part 26A of the Companies Act. The new restructuring plan, the most sort of high profile example of this being used since CIGA's come into force is by Virgin Atlantic, who have recently had their restructuring plan approved. The restructuring plan consists of a two-stage court application process. As part of stage one, creditors that have an economic interest in the restructuring would be invited to meetings. Dissenting creditors will be bound as part of the new restructuring process, and it includes what's known as a cross-class cram down. So it will, across the classes of secured and unsecured creditors and people in different categories, will be included if the restructuring plan is approved. There's talk of the types of businesses that may apply or avail of the new restructuring plan. In my view, it is going to be the large blue chips. I wouldn't expect small to medium businesses to apply or look to avail of the new restructuring plan. And again, coming on to what we will discuss going forward, the ipso facto provisions in respect of specific clauses within supply contracts will apply if a restructuring plan is approved. The next thing I'm going to talk about is the temporary restriction on winding up petitions. This is obviously something which has had a big impact on the way in which suppliers can currently sort of pursue debts and take action and enforcement action against creditors. It's one of the temporary provisions that's been introduced by CIGA, and it is currently due to end on the 30th of September. It is again one of the provisions that has retrospective effect. As things stand at the moment, winding up petitions and in certain occasions statutory demands can only be presented in respect of businesses that have a non-COVID related financial impact which has caused a debt to not be paid. So in essence, creditors at the moment are prevented from issuing winding up petitions because if they were to do so, they've got to make some quite onerous statements about the financial circumstances of the debtor company and make positive statements saying that coronavirus has definitively not impacted on the failure to pay that debt, which is quite difficult for a lot of creditors to do. As things stand at the moment, I'm conscious that the 30th of September is less than a week away. My view is still, particularly in light of the new potential second wave and new restrictions that are being introduced, there is likely to be a further extension of the current restrictions. I'm not sure whether that will be just for specific sectors. There's talk about it being limited to the hospitality and retail sector. One of the provisions or the ways in which CIGA has been drafted is that it does include what's known as Henry VIII provisions, which does allow new extensions or extensions of deadlines and things like that to be introduced without having to go back through the parliamentary process. So I'd say definitely watch this space in terms of restrictions on winding up petitions. So now moving on to the key focus for this particular talk today, and that is the impact that CIGA poses on supply contracts. So the main and the most fundamental impact that suppliers will see is that CIGA will prevent, by way of an introduction of a new section 233B of the Insolvency Act 1986, a prohibition on termination of contracts by reason of insolvency. This prohibition applies in respect of any relevant insolvency process, and I'll come on to what those might be, in the next few slides. It applies to supplies of all goods and services, not just IT or utilities supplies, which is something that was previously included within the Insolvency Act. There are a few exclusions and exemptions, and I'll talk about those a little bit more, but the key thing to bear in mind here, which makes it very different to the way in which utilities and IT supplies were protected previously, is that CIGA doesn't require an insolvency practitioner that's appointed over a relevant insolvent debtor to provide a personal guarantee in respect of any continuing supplies. So the impact of CIGA is that suppliers are in effect prohibited from terminating their contracts and forced to continue supplies to an entity that may be in a formal insolvency process. Moving on to the next slide, the other onerous implication of CIGA is that suppliers are also prohibited from doing any other thing by reason of insolvency, which means that suppliers aren't allowed to use the entry into insolvency as a trigger for increasing prices, changing payment terms, demanding that arrears are paid up to date. Potentially, and this is something which you'd have to consider as a supplier, is if you've got guarantees which are included or incorporated within a supply contract, there's an argument to say that if that guarantee is triggered by reason of insolvency, and if it's incorporated into that same supply contract, there's a prohibition on calling in that guarantee itself. And coming up, Paul will give some practical guidance on how future supply contracts can be drafted to try and work around some of the implications of CIGA. Moving on to the next slide, there are also other limitations that CIGA introduces. So termination for other reasons could also be limited depending on when those termination clauses are triggered and when they are enforced or exercised. So where there are non-insolvency termination events, if they've incurred prior to the relevant insolvency period commencing, then the right to terminate does still apply, but that right to terminate must be exercised before the customer enters the relevant insolvency process. There's no limitation on terminating prior to the insolvency process commencing, but once that insolvency process has commenced, the right to terminate cannot be exercised going forward. The other thing to bear in mind, and this comes to brings into play the new moratorium or the restructuring plan that I was talking about before. There's no current prohibition in CIGA on terminating for a new termination event which occurs after the commencement of the relevant insolvency period either. So if, for example, during a moratorium, post-moratorium debts are not paid, that could be a new termination event, and the supplier would be entitled to terminate on those grounds. So moving on to who's impacted by the introduction to CIGA. So it applies as a prohibition on the supplier's rights under a contract. It doesn't limit or restrict the customer's rights at all. So this is something which impacts on suppliers' rights. In terms of the relevant insolvency processes, which have to come into play in order for the prohibitions and on the ipso facto clauses to come about, we're looking at the traditional ones of entry into a CDA, entry into a liquidation, entry into administration, appointment of an administrative receiver. But in addition, the new processes introduced by CIGA, such as the new moratorium or the new restructuring plan, also will trigger the start of the prohibition period on the supply contracts. So that's what's to look out for in this element. In respect of exclusions, which is on the next slide, there are a list of excluded services, which is set out in Schedule 4 ZZA to the Insolvency Act 1986. That applies predominantly to financial institutions and services provided by financial institutions. Some insurance services are also covered in there. As things stand at the moment, there's also a temporary exemption for small suppliers. So that is suppliers who have a turnover of not more than 10.2 million, balance sheet of not more than 5.1 million, or employees of not more than 50 in number. As things stand at the moment, small suppliers up until the 30th of September, again, are not prohibited from exercising termination clauses in the event of a relevant insolvency process. If that small supplier is in their first year of trading, there's a pro rata adjustment of those figures to take into account the new supplier. So it may well be that that termination is still allowed in certain provisions. Something to bear in mind here is that credit unions fall under the guise of financial institutions for the purpose of this. So credit unions are excluded both as a supplier but also as a customer from this element of CIGA. One of the other things to bear in mind, and this potentially applies to construction agreements more than anything else, is that if there's a supply chain, somebody that's further up in a chain could still terminate, and you might find that happens, for example, in construction agreements where that there's a particular party higher up in the chain that might be able to terminate with an interim party based on an end supplier's insolvency. So CIGA in itself doesn't necessarily impact or limit on that, but that obviously can have implications for anyone that's an interim party in that supply chain. So moving now on to the next slide, I'm now going to hand over to Paul, who will talk about some of the commercial implications and how he might be able to help suppliers with practical guidance on working around the provisions of CIGA.
Thank you, Ambuja. Thank you, Ambuja. So you would have heard at the beginning there from Ambuja that this is the biggest change to insolvency in decades. Well, this also affects every supplier that supplies to any customer who potentially could go insolvent. So every contract in that situation, which is virtually every supply contract. So what can we do about it? I'm going to share with you in the next few minutes some practical tips for suppliers. First of all, starting with what you can do in the contracts itself. Often in the contract, you would have a termination clause that provides for termination upon insolvency. That can no longer apply. So what can we do instead? First of all, you could consider reducing your exposure by having a reduced contract term or having a structure that is set up as a framework agreement and a series of mini contracts. The issue with that, of course, is that for a supplier, they would lose the guaranteed revenue that a longer form of contract would give. So it might reduce exposure, but reduce the commercial benefit as well. There are several points that could be looked at in terms of reducing exposure in terms of the payment terms. So first of all, load it more so payments are made more upfront. Get more advance payments in the contract. If you are providing credit, make the credit period shorter. Instead of 60-day payment terms, make it 30 days. And if there are payments to be made in arrears, then think about charging in installments, being able to invoice gradually. And one of the things I get quite hot under the collar about when I'm negotiating contracts for suppliers is the right to have a right to suspend or terminate the rights, or to suspend the performance if there is late payment. And customers sometimes say, well, you can't do that, you can't turn off the taps. And we say for the supplier, well, pay what you owe then. If it's an undisputed debt, you shouldn't be late. Payment matters to us, delivery matters to you. And where the negotiation often ends up is in a situation where if there is a late payment, there is then a process where the supplier cannot turn off the taps until they have finished that process. So if there is an administrative error on the part of the customer, then the supplier has to just carry things through, maybe give 5 or 10 business days warning before terminating or suspending. I would say keep that process truncated. I've been involved in contracts where that process has been 2 months, 3 months. Keep it as short as possible. There's no reason to be late. 5 days notice and we'll terminate, or more likely suspend. And that, of course, is important in the lead up to a possible insolvency process, so that you don't lose the rights, because the insolvency process will then stop any prior rights. But also, if you're forced to supply after the process has started, it reduces your exposure. Think about a clause having time of the essence for payment. Time of the essence escalates the payment obligation to one of a fundamental nature, so that if there is any delay, then the supplier can terminate the contract for any delay at all. I suspect the customer would resist that for the reasons just given. And then third-party guarantees. If the guarantee is not linked to the insolvency itself, but an ongoing obligation throughout the lifetime of the contract, think about having additional people who could step behind the customer in the event that the customer doesn't pay. Doesn't have to be triggered by insolvency. So it could be a parent company or someone else, a large owner, for example. And now moving on to the next slide, some more tips. If you're supplying goods, then no doubt you have a retention of title clause in your contract, so that you retain ownership of the goods until you've been paid. I've seen clauses, I've seen contracts where this can only be exercised upon the happening of an insolvency event. Again, do not do that anymore. Change your contracts if you have that in them, because the mere fact that there's an insolvency process can now stop you from being able to exercise that right. So the retention of title, being able to reclaim your products, that should be exercisable at any time, and then it's not linked to the insolvency process. Other things to consider would be insisting on regular financial reporting obligations on the customer, perhaps monthly governance meetings where the customer has to disclose how they're doing with payments generally, or you can discuss a change in their credit rating. And link that obligation to a material breach. If they don't provide that financial reporting, then that would justify termination. That's how serious it should be. And think about other forms of termination. A wider form of termination clause that is now often adopted is a termination right for a supplier where the customer's position financially deteriorates so as to reasonably justify a supplier's view that the customer's ability to perform is now in jeopardy. Very wide, that, and a customer may resist it, but that at least gives some sort of element of objectivity. And then keep the right to terminate for insolvency, but make sure that the trigger events are not the start of the insolvency, such as going into a liquidation or an administration, for example, but make sure that it happens before that. For example, when a petition or a notice is filed, or a charge holder becomes entitled to appoint a receiver, or any steps are taken towards entering into an insolvency procedure. So that's before the insolvency procedure has started. Termination for convenience, if you can get it, so that you can terminate without cause. But then the customer will probably want a mirror right to terminate without cause the other way. And that's probably not what you want. So think about that one carefully. Okay, now for some practical tips that go beyond the contract. Before entering into a relationship with a customer, conduct even deeper financial due diligence than ever before, given the increased exposure. And then once you've started the contract, things can change. So pay more attention if customers are late paying. Watch for the early warning signs, the delayed payments. Often that can be put down to other reasons, but it's a real trigger. Don't dismiss them. Make sure your debt collection procedures are tightened up. Don't stand for late payments, be on it. And consider taking out credit insurance. And in terms of other practical tips, conduct other practical tips: familiarise yourself with the contract rights and positions so that you are ready to act quickly, you know what your rights are, and train your staff to do the same, and so that they're also aware of this new law. They may not be. So even more important than ever is that your staff are ready and they can report to you when anything might be starting to go wrong, and then do react quickly to avoid losing any pre-existing rights that arise before the insolvency process, so that you can terminate quickly just as the thing is setting in. And generally communicate. Speak with the company or the insolvency practitioner. If you've got any concerns, discuss it with them. But also, if the entity has gone into an insolvency process, speak to them then as well. There are steps you can do. And throughout, speak with a specialist insolvency advisor, such as Ambuja, because 2 reasons. 1, do not lose your rights in the important period leading up to an insolvency process. And 2, once the insolvency process has started, make sure that you are then familiar with what you can and can't do at that stage. So I'm now going to hand back to Ambuja, who will help you with considering what to do if the worst occurs.
Thank you, Paul. So in my view, and Paul and I have been having discussions about this, is whilst the immediate reading of CIGA and the ipso facto provisions in particular sound like it's forcing suppliers to continue supplying to a hopeless cause. And one of the things to bear in mind is that in practical terms, it may well be that the insolvent entity or the insolvency practitioner that's appointed over the insolvent entity actually doesn't want continuing services or continuing supplies of goods. So the first thing that I would say is check whether the supply is needed. Just because you can't terminate doesn't mean that the customer wants you to continue supplying. In terms of numbers and stats at the moment, insolvencies in England and Wales are down in terms of numbers. They're down by about a quarter compared to the last figures we have is up to August last year. And in comparison, insolvency figures are down a quarter compared to August 2019. But in terms of the split between the different types of insolvency processes, the vast majority of insolvency processes that companies apply for in this country are liquidations, which are a terminal insolvency process, which usually results in the insolvency and the insolvent entity ceasing to trade immediately upon entry into liquidation. Administrations, which are more of a rescue process, only form a small percentage of corporate insolvencies, and I think the ipso facto provisions and the requirement for continuing supplies are likely to only come into play when you're talking about companies in administration, companies that are availing of the new restructuring plan, or companies that are availing of the new moratorium process. But in the vast majority of liquidations, for example, it's not going to apply. Again, obviously, company voluntary arrangements is something where it would continue to apply as well. But check about the insolvency process and check whether your supply is needed. So it may well be that you're not being forced to supply in a situation where you don't want to. So see if you can get the consent of the insolvency practitioner in question. Secondly, there is a provision within CIGA for a supplier to make an application to court to terminate a contract on grounds of hardship. Now, as things stand at the moment, we have very limited guidance on what hardship might constitute and what you might need to prove that as a supplier you're suffering hardship. There's been some commentary which suggests that it's got to be as strong as the supplier themselves having to seek insolvency advice or potentially put themselves into an insolvency situation if they were forced to continue to supply. Having said that, we are in respect of CIGA expecting a lot of new and ancillary guidance and legislation amendments, clarifications to come about. And just by way of example, since the 26th of June of this year, when this came into force, we've had at least 7 amendments in respect of different elements of CIGA. So it is very much a new act. It was rushed through, and there will be changes and more clarifications coming about. So it may not be as bad as things seem at the moment. But obviously, if there are any concerns, please do ask myself or Paul, and we can help you through the process. So now, if we sort of move on to potentially some questions and answers, and see if there's anything that we've not covered during this seminar that you may want covered. Before I move on to sort of the more formal questions, because I can see that some have come in through the chat box, and I'll hand back to Nick to chair that element. One of the things that I wanted to ask is that this particular talk very much is focused on supplier rights within CIGA, but there is a whole other element of CIGA in the way in which it might apply to insolvent entities themselves, and there's other various provisions of CIGA which I've not covered today. So I was wondering if we could just put up a quick poll just to see if there's any other elements that you would like me to cover which haven't been covered today, and we can work on getting those across to you as well. So if I can ask for votes to come in, that would be very helpful. Thank you. Thank you very much.
I think we're probably just about there now. So thank you very much to Ambuja and Paul. Very interesting from both a insolvency perspective for me and also the commercial perspective as well. In terms of questions, there's been a couple in the chat box, although sort of around the same thing. So Ambuja, I think this is probably one for you, and it's the question of, does CIGA apply to public authorities such as a council or a university as well? Now, I don't know whether this is coming from the point of view of the council or the university becoming insolvent, and whether that's possible with councils or not. Or I suppose the question is, in what scenarios might it be applicable to councils or universities, given that predominantly they are not a supplier, or sorry, they are not, supplying in terms of goods and services as such, but maybe there are situations in which they would be considered a supplier, and it would apply.
So my view is, in terms of universities or councils that are the insolvent entity, universities, as it depends on how they're incorporated. So private universities that are set up as limited companies, the protection afforded by CIGA does apply to them. So anybody contracting with private university would be bound by the ipso facto provisions within CIGA. Having said that, the vast majority of universities in England are set up by way of Royal Charter. So from that point of view, CIGA won't apply. So it depends on the incorporation and the nature of the university in particular. And similarly with councils, councils aren't generally incorporated, and CIGA very much applies to companies as its premise. Just slightly related to that, in terms of an exclusion provision, if the contract in question forms part of a public-private partnership and is a contract for the supply of goods or services, then the inclusion of section 233B doesn't apply in respect of it, and that's one of the exclusions that's set out in Schedule 4 ZZA of the Insolvency Act. So where we're talking about public-private partnership contracts, that's something to look at in a separate way as well. But if any of the attendees do have any particular questions, I'm happy to go into details with them offline as to how it may impact on them.
Great, thanks Ambuja. We've had another one in which I'm going to throw to Paul, and I'm particularly interested in this one. On the additional termination clause regarding reasonableness and deterioration of financial position, it's very vague. What does reasonable mean in that sense? Which is a great question for any lawyer.
Well, Nick, I'm tempted to hand this back to you as a litigator, but I would take it since you've got control of the chair. So it's a very good question. Reasonable, it's like material, reasonable, what do these things mean? And context is everything. I was just throwing out there some potential wording. If you wanted to get rid of reasonable altogether, so it could be totally subjective, so it could be any position where the supplier believes that the customer is their ability to perform is in jeopardy, take out reasonable. What reasonable does is include some sort of element of objectivity, rather like reasonable endeavours. What would someone in their position reasonably do? So what I would say is if the position has deteriorated and the supplier is concerned by the creditworthiness, maybe there's been a history of maybe payments getting a bit later, I think they're justified on a reasonable basis, on an objective basis, from taking a view that they're concerned about things being in jeopardy. And of course, the more that the supplier engages with the customer and things don't improve, the more evidence there is that the supplier is justified. But I think the thing is here, we're throwing out a suggestion. This is a halfway house between termination for convenience, where you don't have to give any reason whatsoever, and having to totally justify what you're doing. So I'm sure that there are other suggestions which are floating around in this new world, and if anyone has any other thoughts, I'd be very happy to hear them, including from Nick. Nick, do you have any thoughts? There you go.
So as a litigator, when I see the word reasonable, I think, well, we're never going to agree on that if it's got to the point of litigation. So what does reasonable mean? Generally, in any sense, the best answer I can give is, well, whatever the judge ultimately hearing this considers reasonable to be. So yeah, I was going to say I'm not a fan of the word reasonable in any contract, but actually as a litigator I am, because that means we can argue about it until we're red in the face and until we get in front of a judge. Okay. Right, there are a couple of more queries in there that I will pick up shortly. I just had one, I think probably for Ambuja. So we've got this general concept that suppliers can't terminate. I just wanted to know what would happen in practice if you're not actually terminating. You're not saying we've terminated the contract or you're not relying on any clauses, but you just stop supplying. What in practice do you think would happen?
Now, this is one of the glaring omissions from the Act, and this is probably as a result of it being sort of rushed through in order to address all of the issues that have come about with the pandemic. I don't know how you can, as an insolvent entity, force somebody to supply if they just fail to do so. You've obviously got the ability to sue for specific performance. You could potentially apply to court for an injunction to force them to act in a particular way. Is that going to be reasonable or feasible or commercial for an insolvent entity to undertake? Probably not. In practical terms, and this comes to the negotiations that you have with the insolvency practitioner. And if you're a supplier and you're the only supplier of a particular good or service to this particular entity, and there are no competitors or no one else that the insolvency practitioner can go to, then you could potentially have some kind of discussion with them, negotiate some terms which are favourable to yourself, and continue supplies once you're happy with them. If you're in a very competitive market, then the insolvency practitioner or insolvent debtor is likely to say, well, if you don't want to supply, I'll just go off and I'll get this from somebody else. Now, both of those are slightly outside of CIGA, but it's no different to what currently happens where an insolvent entity and an insolvency practitioner wants to continue trading. So, for example, if you've got a trading administration, as we move to a more debtor-friendly process and suppliers get more used to what happens here and what the implications might be, it may well be that everyone takes a little bit more of a relaxed view. But at the moment, I appreciate that it's a very, very scary thought for a supplier. And again, throwing back to your litigation thing elements, if somebody fails to do that, they could be sued under CIGA, and the likelihood of that happening, if you're dealing with somebody who's insolvent anyway, is probably minimal. If it does happen, then the risks in terms of damages could be high.
If they're unlikely to sue you because they're in a difficult financial position anyway. However, if they went under, would it be a claim that the insolvency practitioner could then bring?
Yeah, absolutely.
So it might not be an issue at the time, but if it forces them under, you could face an action at a later date when an insolvency practitioner who has a pot of money or some lawyers willing to act on a no-win, no-fee, then you could start to see the implications of it. Okay, thanks, Ambuja.
Nick, sorry.
Hello, Paul.
Hello. Sorry, I don't mean to jump in, but there was a couple of things that came through on the chat that are linked that I can just answer very quickly. Just to reiterate something Ambuja said earlier, the issue with the rights to terminate and who loses those rights, this only applies when the suppliers are trying to terminate because of a customer's insolvency. It's not about the supplier's insolvency. The customer can still terminate at any point if they have the right to do so under the contract in respect to the supplier's insolvency.
Great, thanks, Paul. While I've got you, I was going to ask this other one of you, which is sort of the practical points of view again in terms of drafting. So we've got a question here, which is it best to keep in the termination provision, the sort of termination insolvency clauses that you've already got, and add in extras? Yes. Or I suppose the other question is, do you completely redraft in light of this?
There's no reason to take them out. They don't do any harm. The only reason would be it's like adding more irrelevant stuff in there, but it doesn't harm you. It's not like it doesn't make the contract void. It doesn't mean that it would get locked up in prison. And the other thing to think about as well is if you've got this in a standard form contract and you're dealing with customers in other jurisdictions where this doesn't apply, then it's still worth having those clauses there for that reason. But otherwise, I would tend to have a clause terminating for insolvency that kicks in at an earlier stage anyway, because that would protect you under even more scenarios.
Great, thanks, Paul. And another one, I think, on your sort of suggestions, not so much on drafting this time, but one of the practicalities of trying to find out any issues early and doing a bit more due diligence, or in fact putting in clauses that allow you to obtain the information. The point being made here is that some suppliers will hide their financial condition. How can you mitigate around that and access the information via contract provisions?
So this goes back to the point I was just making a couple of minutes ago, that if we turn it on its head, so it's not about the supplier but the customer who's hiding it, and just take it from there. Yes, people might well hide it. They might hide it in the lead up to a contract, and they might hide it in governance meetings and the ongoing relationship. So I would say there are plenty of ways of getting financial information about businesses through searches. Do your own searches, look at any sort of reports that are in the press, and just also keep an eye on what you're seeing for yourselves. If the customer is taking longer to pay and they're not answering the phone or email when you're chasing for payment, that's suggesting warning signs. So there are lots of things to do. I'm conscious of time, and I'm not going to go into them all now, but it's not relying on the customer who may not be willing to play ball at that stage. But by having something in the contract that makes it a material breach if they don't provide prompt and accurate information, you've then got another stick to beat them over the head with.
Great, thanks, Paul. And just to follow up from a litigation point of view, I mean, if you've got a provision in there and they are not sticking to it, then it's not necessarily having to bring an entire action for, damages for breach of contract. You could go for specific performance or delivery up of that information, which might be a shorter process. Okay, we are coming up to the hour's time, so I will just put this final question that's just come through to Ambuja. Can we apply this right to overseas customers, although appreciating that it is a UK specific act?
So that's an interesting question, and there has been a lot of discussion about how this applies in respect of overseas companies. And first thing to bear in mind is that it applies to, I'm going to say English, insolvencies in Great Britain. So if it's an English insolvency, then I would say that CIGA applies. If you're a supplier supplying to somebody that's using an English insolvency process that is a corporate, then I would say there's an argument to say that CIGA does apply. If it's an overseas customer with an overseas insolvency, then I don't think CIGA does apply, and I think it would be hard for that customer to use English insolvency law to force you as a supplier to supply to them. There are obviously methods and mechanisms in which overseas insolvencies can be recognised in England, and so if that process happens, then potentially it could apply. If you're so that's probably, I hope I'm answering the question there. So it's not an automatic, and if you're a supplier, bear in mind that what CIGA does is CIGA prevents you from terminating under insolvency. So you probably don't want CIGA to apply if you're a supplier, because you want to be able to preserve your rights in full. I know that there was another question that the same person asked before about if you're supplying to a university which is established by way of Royal Charter, how does that impact on your supplies? A university that is established by Royal Charter, CIGA doesn't apply to. So as a supplier, your contract will apply in its current form. There's no prohibitions or restrictions on your contract, as a result of that university going into an insolvency process. As a complete aside, at the moment there's not any university formal insolvency process for universities established by way of Royal Charter. So generally you won't find universities, as things stand at the moment, facing formal insolvency. Again, that's one of these watch this space things, because the government are constantly introducing new elements of law, because university insolvency may be something that we have to think about in the months to come.
Great, thanks Ambuja. Well, that's brought us up to the hour mark, so I think I will just draw things to a close by saying thank you to Ambuja and Paul for a very interesting talk. Thank you to all of you for coming along, attending, sharing it with us, and also raising the questions, which I hope we've done service to and provided answers for. So thank you all for your time. If you have any queries arising out of today, then please drop us an email. Equally, if there are areas of law that you would like to hear further about, so ideas for future in-house lawyers talk, then please let us know. But otherwise, thank you very much. If you do have any further questions, we'll probably hang around now. So by all means, join us on a video chat. You can ask them in person, but otherwise we are drawing to an official close. So thank you, everyone.